Then, according to Zungu, not me, Zungu says then he told, the other way, accused one told him that he'll be going to Mpumalanga.
That is correct, my
Am
lord.
I correct so far?
You are correct, my lord, 100% correct. That is the evidence.
So the telephone records, whose telephone records appear in Mpumalanga and whose appear out of Mpumalanga? According to your submission now.
According to my submission, my lord, the telephone records that we have is of accused number 1.
That's it?
It picks up his tower in Mpumalanga. And the other person that is being contacted or is making contact with him is Constable Zungu.
Okay.
Simple as that.
Yeah.
We do not have the telephone records of Constable Zungu, but we are relying on the cell phone or data of accused number 1.
Okay.
And then Mr. Zungu, on the date when he says they tried to shoot him, he makes mention of a person. He said his name is Nkanzimulo. And then what Mr. Minister does on the 28th of October 2014, on the 11th of June 2025, put it to now, Warrant Officer Ndlovu, that the person that took a photo depicting accused number 1 wearing a red shirt and a jean standing next to a vehicle was a person called Nkanzimulo. So there's some sort of corroboration in what Zungu says, that the person that happens to have wanting to kill him to be a relative of accused number 1 is confirmed by what accused number 2 puts before the court.
So it's not denied that there's a human being called Nkozimuntu
Exists, yes.
who exists.
Yes.
And apparently, according to Zungu, that's the gentleman who attempted
to kill him or to shoot him. Don't know what was the purpose of the shooting. Maybe wanted to scare him.
He only mentions one name, Zungu.
Mentions 2 names.
The other one, is it an uncle or what?
Uncle of accused number 1.
Who's supposed to be a
relative of accused number 1 and 5. The other person is an Ntuli person, relative of accused number 1 and number 5.
Okay. Yeah.
Paragraph 31.0 or 10, response to paragraph 14.22. Constable Zungu testified that they went to Tops together with accused 3 and 4. There was a certain shopping center there. They bought liquor. They then went back to the hostel. That's on record 7 September 2023 on page 10. Paragraph 31.11, response to paragraph 15. As indicated in our heads, credibility plays no role at the section 174 stage unless the evidence of the witness can be said to have been utterly destroyed. We submit that it can be said that Constable Zungu's evidence has been destroyed. It must also be borne in mind that as it was cannot be said it was utterly destroyed. As it was held in Peter's case, referred in our heads, the court can accept certain portions of a witness evidence whilst rejecting certain portions. The role that accused number 4 played is set out in the extracurricular statements of accused number 2, being present when there was a briefing at the hostel to kill the deceased, received the firearm from Simpiwe and handing them to accused 3 and the other accused, acting as a lookout and positioning himself at the window of the Kumalas, running into the house after the deceased was shot and after they had departed the scene and returned to the hostel, asking accused number 3 if he is sure that he had killed the deceased. Paragraph 31.12, that paragraph...
Sorry to disturb you, just before the thought escapes me. The gentleman who's allegedly said to have been murdered or killed by Gwabeni, what was his name, by the way? Allegedly. Hey, Zungu says, according to Zungu says to Gwabeni, hey, when usaphethe na ibhamu lapho. Angithi wena ubulele bani. We forget this evidence.
No, I remember that part of the evidence.
You are busy with a firearm here. Didn't you say this 38 you used it to kill so and so?
He did, my lord.
So is there evidence like that, Mr.
There is evidence like that, my lord, but I cannot remember the name of the individual.
I also listened to the same evidence.
Yes. So what I want to know
Also
is,
confirm that
hello?
it is there as well.
It is there, yeah.
Yes.
Okay, yeah. So all I want to know is, they mention a person who is allegedly deceased to both of them.
It was a
Ubani
lady.
Snook, Ubani
It was a
Gamalaki.
lady. It's the name of a lady.
It's what?
Snako.
Snago.
Yes.
Right. That's why it's Snuku. Couldn't be suit. So Snuku supposed to be a deceased, according to Zungu, by 38.
Yes, my lord, yes. I now
No,
recall
I'm
that.
interested in, because Mr. Numalo says there was no meeting like that. When he submits that there's no corroboration, because there is corroboration of a name at least, of a person who's allegedly dead, and both parties know about that person. Am I correct?
Correct, my
I'm
lord.
summing up that.
Yes, my lord.
Okay, fine. I'll check it out in any case.
No, I recall that name, my lord, but this Sinako name comes
Yeah,
twice.
apparently he attends school, this guy, blah, blah, blah.
There's a Sinako that
Yeah.
I think when accused number 5 wanted to reverse, he asked him to inform Zungu that can he make
fine.
way. So I'm not sure whether it was that the same Sinako
Yeah,
or
fine.
it's another
I hear you.
Sinako.
Okay.
Paragraph 31.12, there's no duty upon the state to call every available witness. The state has made it plain that position of Ms. Kelly Kumar will be considered after the conclusion of this case. Hence, she was not called as a witness. My lord, we have made Ms. Kelly Kumar available to the defense and other witnesses that we have not called at the close of the state case.
Okay.
Paragraph 31.13, response to paragraph 16.8, 16 to 18 DNA. Captain Masetla testified that in DNA analysis, you either include a suspect if his DNA is found on all 16 DNA regions, i.e. a full profile. If not, you exclude, and that there's no partial inclusion. He found a mixture of a DNA on a head, and accused number 4 could only be read in 4 out of the 16 regions. The finding is therefore neutral. Paragraph 31.14, response to paragraph 23, joint possession of firearm. The test for joint possession of illegal firearm and ammunition is well established. The mere fact that the accused participated in a robbery where the co-perpetrators possessed firearms does not sustain beyond a reasonable doubt that the inference that the accused possessed the firearms jointly with them. That was held in State v. Nkosi, 1998, Volume 1, SACR 284. It was the decision from the Western Cape. Oh, Witwatersrand, my apologies, my lord. Witwatersrand Local Division. It was held that this only justifiable if the factual evidence excludes all reasonable inference other than A, that the group had the intention to exercise possession through the actual detenter, and B, the actual detenter had the intention to hold the guns on behalf of the group. Only if both the requirements are fulfilled can therefore be joint possession in involving the group as a whole. The court in State v. Mbuli, 2003, Volume 1, SACR, on page 97, Supreme Court of Appeal, pointed out that where the offense is possession of firearms, or in that case a hand grenade, it is not the principle of common peoples that have application, but rather those relating to joint possession. A conviction of joint possession can only be competent if more than one person possesses the firearm. The court found that the mere knowledge by others that one member of the group possessed a hand grenade or even acquiesced to its use, it is the execution of their common purpose. Paragraph 32, it is submitted.
Sorry, just hang on. Do you differentiate between between a conspiracy and common purpose? Have you checked that? Because people just talk about them like they're synonymous. A conspiracy and common purpose. And also it can include prior planning. You don't These two concepts, you're saying they're synonymous. So
I mean, they're the same.
you use inferential reasoning anyway, you have to, because it must come to the knowledge of the participants who are less than two. I mean,
Indeed so, my lord.
at the most, they are 2 plus. They plan allegedly. And that knowledge of the planning, they are bound by it. Because as it is said that they want to execute a particular project. And if they don't divorce themselves from that project, are they not bound? It's because Mr. Momalo was using Ngedezi. Ngedezi, is it not narrow? If you use the other cases, I'll come with them. If you use other cases concerning
Common purpose.
common purpose and conspiracy, you can be involved in a conspiracy and not be present at the scene. And you can also be involved in a... No, it's the other way. You can be involved in a common purpose and not be at the scene. Is that not so?
That is so, my lord.
Sometimes you can be involved in a conspiracy and also not be in a scene.
In the scene, that's correct.
So when you say if a person is not at the scene and yet is involved in a conspiracy, are you excluding him even for conspiratorial purposes, or how do you reason it?
I think it's the manner in which we use the words interchangeably.
Interchangeably, okay,
Yes.
fine. I hear you.
In paragraph 32,
Okay.
it is submitted that the application for discharge ought to be dismissed. And that is the end of our... Apologies, my lord.
Yeah.
That's correct, my lord. Just been reminded also to just place one aspect before I pose regarding the first appearance of this matter at Boksburg Magistrate Court. That is on Exhibit EE. That is before court now. Accused 3, and I'm not quoting him verbatim, my lord. He says that when this incident of the 26th of October happened, he was, or they were incarcerated, which is in direct conflict with what we have seen in this matter. The Exhibit S, what Ms. Pinkifa Fillingham has told the court, what he has said through his lawyers, Mr. Munisi, as well as Mr. Ngomalo, that they were enjoying this joyride in a Kumbi with Sigayo, Mfaka, Telimpilo and others. He was not in custody. He was outside when the deceased was shot and killed. That was his first.
Where do you get that evidence?
Exhibit EE, my lord.
EE. What does
That's
EE
correct.
say?
It's a transcribed record of the first appearance at
Yeah.
Boksburg.
Who was making that declaration?
Accused number 3.
Through his attorney. Sorry,
Himself,
counsel.
personally.
Hello?
He made it directly to the court.
Oh, personally.
That's correct.
He tells the court, when this thing happened, I wasn't around Joburg.
I was incarcerated.
Or Gauteng, I was incarcerated.
That's correct. The record is there. Speaks
it's
for itself,
recorded.
my lord. We have the transcribed record is before
No,
court,
fine.
my lord.
No, I just want to know if it is. Then I'll check it.
That's correct.
And Mr. Ngumalo, what does he say?
No, it can't be checked.
Hello?
It can't be checked later. It must be checked now.
No, you don't know about that.
No.
Okay, fine. If you don't know-
I've never heard.
If you don't know about that,
No, it's
fine.
news to me.
Okay.
Yeah.
It's news.
May I also make a follow-up, my lord, because
never
it affects my client very directly. The court will note that this is not a time to introduce new evidence.
It's not new evidence, Mr. Nis. If it's recorded,
I am not saying that
if
this
it's
is new
recorded
evidence.
before Mr. Ngumalo started addressing this court, it can't be
Yes.
new evidence.
My lord, I am saying,
Yeah.
and if the court can hear me, and please
Okay,
hear me well,
yeah.
please. I'm saying this is not a time to introduce new evidence. And that information that Advocate Sibanda says before he sits down, he wants to introduce it, should have been information, had it been brought to our attention. If that was the state's case all along before they closed their case, definitely that information would have been a subject of a trial within a trial to determine the circumstances under which accused number 3 allegedly said all those, whatever it is alleged that he said it. But now that he says it now, my lord, now that it is said that he said it then, but that information is being introduced now.
No. You're talking at cross purposes. According to your colleague here,
Yes.
the doctor, he says this was said at the first hearing.
I'm going to request.
It's like a plea.
Yes.
First day you plead guilty or not guilty, and you say not guilty.
No, it can't be like a plea, my lord, because there's a specific format that prerequisites that lead to a plea. In other words, precursors to a plea. They explain your rights to legal representation. You make a decision whether you're going to conduct your own defense, whether you're going to be assisted by legal aid, or whether you will have your own attorney, and the implications of you saying something. That must be explained to you. So we don't know if those circumstances before accused person actually uttered what it is alleged that he uttered, those circumstances were explained to him, which is the reason why I say if the state wants to rely on that information, it should have been something that was brought to the attention of accused number 3 in conjunction with me, so that we map a way forward as to the admissibility of that information. But as is now, that information is totally inadmissible. Unless it should have been a subject of a trial within a trial, my lords.
Let's hear, Doctor, what are you saying? They say you can't use that information.
I'm accused number 3, my lord.
Yeah.
A request to see me.
Okay.
Thank you. I'll wait for Mr.
Yeah, hello?
I'll wait for my colleagues.
Okay. Have you heard of a case called State versus Nkoshe, 1949? Anything, that decision says basically, anything which says by counsel or his word in court, it's recorded.
That is correct.
Everything. 1949, I was 2 years old.
I was 5 years old.
Yeah. Yeah, okay, let's see. Yeah.
I'm instructed by my client that he would want the record of the 26th of October. Sorry, not 26th. Of the 27th October 2020 when they appeared in Boxback, because to him it's news. News. I've also never heard about that. Thank you.
As it please the court.
We've got it, that record. You remember there was a dispute about what the magistrate should have said and didn't say. And then somebody brought the typed record. Is that not so? Of the 7th of July. 27th July, sorry. Yeah, you're right. Okay, fine. So you want to see the record?
We want that,
They say they want to see the records.
Charge sheet.
The record?
The charge sheet of, reflecting the date of the 27th of October,
Okay.
2020.
Yeah,
But
fine.
I thought,
This is mine. Oh, this is.
I thought Mr. Ramosipil will bail me out as an attorney because this when we introduced the information, it pertained to his client, and it was discovered during trial within the trial when we were dealing with the issue of. But when we introduce a document, we do not say this document only binds this one. It's a document before court. You can use it anyway, anyhow you want. The document was disclosed. And Mr. Ramosipil can bail me out. I trust him to do that. He knows.
He knows.
Yes.
No, but it doesn't answer to our concerns. Still,
We cannot just disclose a document, my lord, to Mr. Ramosipil. We disclose to all of them.
Okay, fine. So,
But
are we
if
good?
they want the document to be disclosed, I can email it to them now, or we can print copies.
Print them.
yes.
Print the entire.
But for now, my lord, I'm going to read what accused number 3 said.
Yeah, okay, fine.
But before I do that, because I know this court wants authority,
Yes.
so I'll start with the authority.
Yeah, fine.
Section 235, subsection 1 of the Criminal Procedure Act, proof of judicial proceedings.
As it please the court, madam, that is exactly what I said. This is an application for a section 174. This is not a time of losing evidence. And this application is got to do with accused number 4. If the state wants to reopen their case, they are welcome to make an application and say, having traversed the application in terms of section 174, there is this other information that we also want to introduce that relates to accused number 3. May we kindly reopen our case? But things cannot be done haphazardly the way in which it is suggested that they should be done here, my lord.
I haven't heard what Dr. Sbanda, I don't know what he wants to say.
No, he says exactly what I'm
let him
explaining
repeat-
to the
let him
court,
re-
my lord.
let
He
him
wants to
say-
introduce this new evidence.
Let him say what he wants to say. I don't know what he wants to say. What do you want to say, sir?
My lord, I was just making my last submission to say this is what accused number 3 said during the first appearance, and then there was this.
And then you wanted to quote something.
I wanted to quote to say, but this evidence already is before court, and then it was brought in terms of this section, proof
Yeah,
of
so
judicial
let's
proceedings.
tell us, educate us about that section.
Section 235, subsection 1 says, it shall at the criminal proceedings be sufficient to prove that original record of judicial proceedings, if a copy of such record certified or purporting to be certified by the register or clerk of the court or other officer having the custody of the record of such judicial proceedings, or by deputy of such registrar, clerk or other officer, or in the case where judicial proceedings are taken down in shorthand or by mechanical means by the person who transcribes such record proceedings, as a true copy of such record is produced in evidence at such criminal proceedings, and such copy shall be prima facie proof that any matter purporting to be recorded thereon was correctly recorded.
Okay.
That's it.
And so what was recorded according to you?
And then I want to place on record what was recorded. And I'm just placing that relevant passage. Accused number 3. Okay, I'll start with the court. No response from accused 1. Accused 3, Mr. Mnubi, do you wish to respond to the explanation about legal representation? Your Worship, accused 3. Your Worship, I do not see the necessity of having a legal representative because I do not know why I was brought before court. I will not enter the accused dock, Your Worship, because I do not feel, then there was no recording. Your Worship, the police officers, they were with other people. They came to us. It is alleged that at the time of the incident that we were outside, and it was later discovered that we were actually incarcerated. On actually what had happened, and that again, Your Worship, and decide as to what happened, and again, Your Worship, our constitutional rights had not been taken into consideration in that regard. So even at this time, Your Worship, they are not taking our constitutional rights into consideration, and that we, the people who actually committed that offense, they were outside, and that time we were incarcerated.
Okay.
And the date of this was 27 October 2020, and what I was reading is on page 4 and 5.
Yeah, fine.
As the court said. Then I will pause here, my lord.
Okay. So what do
I
what
will
do
now
we do?
hand over to Advocate Baloyi, my lords.
Yeah.
Yeah, court, please.
I thought Mr. Ngumalo wants to respond. You said you wanted to respond to the Makalani. Yeah.
The interpretation first.
Oh, the interpretation first. Okay, fine. What's the time now?
I don't think this whole
I
the
don't-
state took the whole day. I don't think I can do it in 30 minutes, my lord, please.
Oh, so you suggest we do it tomorrow morning?
Tomorrow I'm in Joburg High Court.
Well, somebody's coming here, is it not?
I would like somebody to come, but he asked me to assist him because he struggled yesterday with this document.
Oh, is that so?
Yes, that's
So, Joburg, are you presiding there also?
my lord. It's a recruitment. We are pressed for recruitment. We
Is it?
are even working this past weekend, Saturday and Sunday.
So that
So the
gentleman
principal is on sick leave. They asked me to come and stand in for him in shortlisting. But on Thursday
Can
I'll
I
be.
make this submission? It is very unfair for the interpretation not to be done from the morning when the submissions were made. And reference have been made with our clients. They don't even understand what has been said about them. And then now the matter is going to be adjourned when they have not been following the proceedings.
I thought he said he'll read the two documents. That's what I thought you said. Yeah, well,
No, I was just saying, in fact, confirming what my colleague is saying, because I could hear them saying, "Asiyezwa ukuthi kuthiwani," meaning that they don't understand what is going on.
It is true, my lord, it was said. I think there was an agreement that Mr. Numalo the state should go, and then at the end, I agree that was. But if they want to do it, I can go. I was only saying the time. But if it's a concern, I can then do the 30-something pages now.
yeah, fine. Please do that.
Okay.
And you must read everything on those pages. I need to understand
It's in English.
Yeah, and then you
I
interpret
must-
it into English. Okay. So which document are you reading now?
It's the reply from the state, my lord.
The reply from the state.
I don't know whether Mr. Numalo's one was done yesterday. I don't know.
It was done.
It was done yesterday.
Yeah, yesterday there was
No, it's fine. It was done yesterday.
it was done. So interpret the heads of argument of
By the state.
the state. Eh?
7 page 4. 7 page 4. The judge started on page 4.
You know, to be fair, let's do it the other way around. When you read it, just start by saying state submissions, re-application for section 174, Act 51 of 77, discharge application by Mtotogis Mapisi, accused number 4. Lena impendulo is this one. Then you do it in Zulu. So you read English, thereafter you read Zulu, so that nobody can say, Awuzwanga or Atakazwanga in. Okay, let's do it that way. We interpret it same time. You read it in English, you interpret it same time, just like that, until we finish that document. Okay. I see you're smiling, Mr. Are you?
No, don't say.
He said I must read and then.
No, I was having a concern, my lord, that it was done in English. It went through in the English version by my colleague, Dr. Siband. So he can just interpret.
No. Let him do it the way we should do it. You read the English heads and then you interpret them into Zulu. Fortunately, every gentleman here is Zulu speaking, so it won't be so to Zulu. Yes, sir, you may start.
I've never done it the way the court says I must do it, my lord. The court is making it difficult. I've never done it that way, my lord.
What's the difference?
It's already in English. I must just do it in isiZulu, my lord.
No, just do it the way we suggest you do it. Because they won't know what are you interpreting. Because these gentlemen, they can hear English. And I repeat, I once had a gentleman telling me that he certifies document in Rustenburg. He takes that document for certification. And I told him there are very few judges who can express themselves like you. So so read it for them in English and then interpret it in Zulu. That's how we should do it.
State submissions, re-application for Section 174, Act 51 of 1977, discharged by Mthokoziseni Mapisa, accused 4. Ize uphendula-ke kumbuso kwizethulo mayelana nesicelo sokudedelwa-ke ngoba ubufakazi bungekho obungabangela-ke noma bungaholela ukuthi le nkantolo ithole yena-ke uMthokoziseni Mapisa umsolwa wesine nokuthi angalahlwa icala. Ufakazi-ke noma-ke icala lawo umbuso kunofakazi-ke about 60 ababiziwe umbuso. About 60 witnesses testified for the state, and their evidence can be broadly classified in the following categories. Abantu ke, the people who were in the house when the incident happened, abantu ababephakathi endlini uma isigameko senzeka, the neighbors of the Khumalos, omakhelwane bakwaKhumalo, the police officers who attended the scene, Mthethwa Mathebula, amaphoyisa ekuwona aya kwindawo yesigameko, uMthethwa noMathebula, the forensic field officers, Warrant Officer Musia and Colonel Mhlahlo, amaphoyisa ke asebenzela ngaphandle ke uWarrant Officer Musia noma kwakuSergeant Musia ngaleso sikhathi kanye naye uKolonel Mhlahlo, the ballistic evidence Colonel Mangena, Sirewo Ntini Hrobla, Rolofse, amaphoyisa asebenza ke kuhlangothi lweibhamu uKolonel Mangena, uSirewo uNtini uHrobla kanye noRolofse. DNA evidence ubufakazi ke bolibofuzo Captain Masitla, confessions accused 1 and 2 pointing out accused number 1, itatimende ke zokugonyuluka zakhe umsolo wokuqala kanye nowesibili la ekwakhonjwa khona umsolo wokuqala. Investigating team Gininda Sergeant Muhula, ithimba eliphenyayo uGininda kanye naye uSergeant Muhula. Corroborating evidence Mr. Lionel Zwane, documentation from LPC regarding Mjiyako, ubufakazi ke obuqinisayo noma obuhambelanayo ke uyena umnumzana Lionel Zwane, amaphepha ke abuya khona ke LPC noma la phethwe khona noma ekulawulwa khona ke abameli mayelana naye ke uMjiyako. Cell phone evidence Colonel Stein, Colonel House, Miss Pinky Vitalingham, ubufakazi ke bomakhalekhukhwini uKolonel Stein, uKolonel House, uMiss Pinky uVitalingham. Summary of the state's evidence. Ufinyezo lo bufakazi obulethwe umbuso. The people who were in the house when the incident happened, abantu ababengaphakathi ke noma ababekhona endlini uma isigameko senzeka, Zandile Khumalo, Mthokozisi Thwala and Tumelo testified that on the evening of the 26th of October 2014, 2 intruders entered the house of the Khumalos, one wearing a hat, a caramel jacket with dreadlocks and with a firearm demanding money and cell phones. Zandile Khumalo, Mthokozisi Thwala kanye naye ke uTumelo Madlala bethula ubufakazi obuthi ke ngobusuku bange-26 October 2014 kwangena ke abantu ababili emzini wakwaKhumalo, omunye ke wayegqoke isigqoko efake ijacket kanye futhi ke enama dreadlocks ephethe isibhamu efuna ke imali kanye nomakhalekhukhwini. Longwe pushed the gunman and ran outside. A scuffle ensued between the people in the house and the intruders. The loud bang was heard and Kelly ran to the bedroom. Ulongwe wase pusha ke lo owayephethe isibhamu wase egijimela ngaphandle, kwaba nokulisana kwabakhona ke phakathi wabantu ababesendlini kanye nalabo ke abangena kwazwakala ke umsindo. uKelly wasegijima ke eya ekamereni lokulala. The second intruder was tall, wearing a hoodie and an O-shaped beard, and followed Kelly to the bedroom. She ran to Senzo, pinned the hoodie man against the wall, and Tumelo punched him. Then the gunshot that made Tumelo go deaf went off. Owesibili-ke owayemude yena-ke owayegqoke ihoodie futhi-ke ney'ntshebe zakhe-ke zingohlobo-ke olubizwa ngokuthi-ke i-O-shape. Yena-ke walandela uKelly ukuya ekamereni abalekela kulona. uSenzo wabe yena-ke esecindezela-ke lo wayegqoke-ke ihoodie obondeni. uTumelo wasemshaya ila ekwazokala khona noma saqhuma khona-ke isibhamu leso esabangela-ke ukuthi uTumelo angasezwa lutho. Tumelo went into the bedroom planning to exit through the window, but bars prevented him. Zandile ran into the bathroom and Mtogo exited the house through the kitchen door. The witnesses found Senzo lying down with a bullet wound. The witnesses rushed Senzo to Butsi